The long-awaited resolution of the legal battle between Ripple and the SEC is on the horizon, and the cryptocurrency community is holding its breath as it has been in the midst of a 2-year-long dispute with the SEC, or the Securities and Exchange Commission, over whether the digital token XRP, on which Ripple services are built, should be classified as a security. The outcome of this dispute could have far-reaching consequences not only for Ripple and the XRP community, but also for the entire cryptocurrency industry. Will Ripple prevail or face devastating consequences? This is a legal battle that could redefine the future of cryptocurrencies worldwide. Hello and welcome to another video of Finance Sense, where we cover all the latest trends in the financial markets and the economy. But before we start, make sure to leave a like, subscribe, and comment below if you enjoyed watching this video, and turn on the notification bell to keep posted. People are eagerly awaiting the resolution of the 2-year-old legal dispute between the fintech startup and the SEC. At this point, everyone is keeping an eye out for any news on the outcome of the long-running legal dispute in the cryptocurrency industry from Judge Annalisa Torres of the Southern District of New York. Several XRP community members have started making predictions about the result of the current litigation between the SEC and Ripple as it approaches its conclusion. While some XRP supporters think Ripple may ultimately win its lawsuit against the Securities and Exchange Commission, others feel the blockchain startup would lose. The SEC has asserted its jurisdiction over cryptocurrencies by filing the accusations. The lawsuit revolves around the issue of whether or not XRP, the digital token on which Ripple's services are built, is a security, a tradable financial asset like stocks or ETFs, or something else entirely. Nearly all other crypto tokens would become subject to the SEC's regulation if the court decides that XRP is a security. This would not only impose costly licensing as well as reporting requirements on cryptocurrency companies, but it would also have legal repercussions for companies that have created tokens or assisted individuals in trading them without SEC clearance. According to defense attorney John Deaton, who provided expert testimony in the lawsuit on behalf of investors of XRP, even significant US-based exchanges might find themselves unexpectedly in the lawsuit. This would be devastating for cryptocurrency companies. To determine whether a cryptocurrency should be regulated as a security, the Howey test must be applied on a case-by-case basis until legislation is passed in the United States. When the SEC accused Ripple and its executives, it stated that XRP had met all the criteria set in the Howey test, and the business had broken federal securities laws by obtaining money by selling XRP. On the other hand, attorney John Deaton, the founder of Crypto Law, made the XRP community happy by describing how Judge Annalisa Torres might declare Ripple the winner in a post on Twitter. Deaton said that although he doesn't think Judge Torres agrees with the Blue Sky Agreement, he thinks Ripple could prevail against the SEC in the prolonged legal dispute that has lasted for more than 2 years. Deaton claims that because the SEC did not apply the Howey test to all transactions, Judge Torres might circumvent Ripple's XRP sales. Instead, the regulator asserted that XRP is a security in and of itself. In this instance, the SEC is essentially using the outdated but-for causation rule. The SEC contends that XRP wouldn't exist if Chris Larsen and Judd McCaleb, 2 executives of Ripple, hadn't created it. Furthermore, the SEC argued that without Ripple, there would not be a secondary market for XRP, according to attorney Deaton. The SEC also asserts that XRP sales in the past and present constitute securities. According to the regulator, Ripple's efforts are the only reason nations outside the US may proclaim XRP as a currency, Deaton remarked. Deaton said that Judge Torres might give Ripple a clear victory by dismissing the SEC's broad accusations since the regulator failed to provide evidence of a specific transaction. Moreover, the Xrp Community Council criticized the SEC for being inconsistent with establishing the common enterprise prong of the Howey test, calling it an extraordinarily all-encompassing theory because that's not how securities laws get applied. An SEC expert testified that the whole XRP ecosystem, including XRP holders, exchanges, and third-party developers, constituted the common enterprise, which caused the SEC to reverse its original position that Ripple was the common enterprise. The SEC dropped the expert's testimony in response to Ripple and the XRP community's repeated objections. According to Deaton, the SEC stated that XRP reflects both the common enterprise and all of the promises and efforts put forward by Ripple. Through his case, he said that the SEC maintains that XRP satisfies the second and third requirements of the Howey test. However, Deaton thinks Judge Torres would deny the regulator's motion for a summary judgment because of the SEC's assertion regarding XRP. Deaton predicted that the case might go to jury if Judge Torres rejects the request for summary judgment made by both Ripple and the SEC. But it is almost hard to make any further predictions until we get a chance to examine all of the Rule 56 facts and all of the supporting documentation cited. The accusations brought forward by the SEC violated the Constitution by grossly expanding the scope of the Howey test. It is also important to note that the SEC conceded in its response to the writ of mandamus that the court would assess whether the SEC's reasoning is legitimate. It should be recalled that in February, Stuart Alderati, chief legal officer at Ripple, predicted that his company would eventually prevail in its fight against the SEC's assertion that its XRP cryptocurrency constituted a security. Additionally, the legislation proposed by U.S. Senators Cynthia Lummis and Kirsten Gillibrand for June 2022 may pass if the SEC prevails. The Commodity Futures Trading Commission, or CFTC, may be given the authority to manage trading in and handling crypto derivatives under such a bill. The latest post by Johnny Deaton outlined some convincing arguments for why the resolution of this case may be particularly important. He believes that only a few court decisions have the ability to affect not only the United States but the whole world, leaving overseas holders in a precarious situation. 99.9% of all court decisions don't have the weight and significance that this one could turn out to have. Rarely does a judge's ruling affect not only the United States, but the whole world. According to Deaton, international holders have been held captive. But Deaton has made a statement expressing optimism that Judge Torres would rule that secondary market transactions involving XRP are not securities. Hi, we hope that watching this video was interesting and that you learned something valuable. If you enjoyed it, please hit the notification button, like, subscribe, and watch more of our videos. Also, don't forget to share your comments in the comment section below. This is Finance Sense, helping you stay current on all the most recent change in the financial markets and economy. Stay safe and look out for the next video.